Welcome to Legal Forum, a public service program of the Lawyer Referral and Information Service of the San Fernando Valley Bar Association. Today's topic for discussion, the consequences of DUI. Dave's guests today are Deputy City Attorney Kenneth So and Attorney Gerald Fogelman. I'm Leon Bennett, and now here's the host of Legal Forum, David Hagen.
Thank you, Leon, and welcome to another edition of Legal Forum. Today's topic is the consequences of DUI, that's driving under the influence. Let's meet today's guests. On my left, Kenneth D. So. Ken is a deputy city attorney for more than 14 years. Over the past 11 years, he staffed Division 101 of the Los Angeles Superior Court, which handles between 7,000 to 12,000 arraignments per year. I did the math, and that's at least 46 arraignments a day. That's phenomenal. Ken also handles the community court in Van Nuys, where defendants are extensively interviewed and given sentences structured to deal with their individual needs or problems. Ken, welcome to the show.
Thank you, David. Nice to be here.
Gerald L. Fogelman. Jerry's a private criminal defense attorney. He's practiced criminal law exclusively for 29 years and has conducted more than 85 trials. He spent the first 4.5 years of his practice working as a prosecutor for the deputy district attorney and has represented defendants individually in a private capacity for more than 25 years. He's past president of the Criminal Bar Association and was named the 1993 Criminal Trial Attorney of the Year. Jerry is a trustee of the San Fernando Valley Bar Association and is on the Lawyer Referral and Information Service Criminal Law panel. Jerry, welcome to the show.
Glad to be here.
Good to have both of you here. So, you've been out to a party, you've had a couple drinks, and you get pulled over. What's in store for you, Ken?
Well, if you've been pulled over, the officers evidently noticed you, probably because of your driving, which would be weaving, straddling lanes, braking erratically, or even driving slower than the speed limit. One of the signs of driving under the influence is actually going 10 miles an hour or slower than the posted speed limit. So once he stopped you, he's going to approach you. He's going to have a conversation with you. During that conversation, he might notice alcohol on your breath. If he does notice alcohol on your breath, he will order you out of the car to conduct some field sobriety tests.
Well, what are some of the field sobriety tests that they do? Is it like walking a straight line like I've seen on television?
Just like you've seen on TV, several of those are accurate. There is the heel to toe walking a straight line. There's the finger to the nose. There's counting on your fingers. They have you write down the alphabet, and these are all basically to judge your level of impairment. There's also what's known as a PASS test. That's a preliminary alcohol screening, which is a pocket-sized device which reads your blood alcohol level. They have you blow into that at the scene. Based upon the factors they see, they may or may not take you down and book you.
Fascinating. What about these field sobriety tests?
I feel the field sobriety tests are of no value whatsoever. I think the main purpose is to find some probable cause to take you in to give you a blood or a breath test at the station. And they have to have probable cause to do that. A lot of times you're going to be stopped for other things than Ken mentioned, and that is for registration tags at night, at 2 o'clock, when the bars close. They know people are out on the streets driving. And that's when they'll be looking for a lot of technical violations, such as tail light, registration tags, and they're going to stop you, and they're going to come up to your window and want to talk to you. And the reason they are is they want to see if they can smell alcohol. And then they detain you for that. The balance tests are subjective. It's usually 2 or 3 or 1:30 in the morning, and you're tired. You have had a drink, maybe 2 drinks, or maybe slightly more. And you've been dancing, or you've worked all day, and then you've went to an affair at night. And so no one is going to do good on the field sobriety test, and they're designed to fail. Some of them, the hand pat, if you do it well, they tell you to speed up. And they tell you to speed up until you fail. And once they finish those tests, then they go in. But I don't think they have any significance regarding what your blood alcohol level is.
Are these the kinds of tests that a person who's completely sober can do?
I do not think so.
What do you think?
That depends on the person. Some people are very capable of doing it. Others maybe not so. But if you're impaired, basically, you're going to do much poorly on the test. And as I indicated, each field sobriety test is just one indication of whether or not you're under the influence. They're also going to take a look at the past test. Your driving, as Gerald mentioned, there are technical violations they can stop you for. But that's just one. The FSTs are just basically to get a broad sense of your level of impairment.
FST, field sobriety test.
Correct.
Yes. I agree with one thing he said, is that one thing we always got to keep in mind is that the reason these don't really tell you the blood alcohol level or whether a person's under the influence of alcohol is because there's no comparison. In other words, this person hasn't been tested by that officer in a normal day when he knows the person has not been drinking, and seeing how he can perform these tests and then do it now and see if there's any difference. So it is subjective, and it doesn't really tell you for each individual.
It's just an indicator, a step for them to move on to the next
Right.
test or move to the next process in a stop.
Which is being taken down to the station, assuming they believe you're under the influence.
Well, I don't even want to get to the station yet. I have a question about this PAS. This is a new thing. I haven't heard about that. What is a PAS?
The PAS, as I mentioned, is a handheld device which delivers a preliminary reading of the blood alcohol content.
Is that an intoxilizer that we hear so much about?
It's not an intoxilizer. It's a smaller machine. It's fairly accurate, and you blow into it for a certain amount of time, and it gives you the reading of the blood alcohol content.
From the breath that comes out of your lungs.
It's a breath test.
Is it admissible? Is it admissible evidence in a court of law?
It can be used as admissible in certain circumstances.
Okay, so now you've been stopped, you've been taken out of your car, you've been given some FSTs, field sobriety tests, you've maybe blown into the PAS. What happens if they move to the next level? Now what happens?
If they move to the next level, they're going to take you down to the police station. There you're going to be offered either a breath test or a blood test. The breath test, as you mentioned, is the ECIR, where you blow into the machine, and it gives you an accurate reading of your blood alcohol content. You can also agree to take a blood test, in which case they'll take you to have a registered nurse draw blood from you, and the blood reading will be, it takes 4 or 5 days, though.
They're taking blood out of people at police stations?
Well, that's only, not at the police station.
Where they take you to a hospital?
Yeah.
To have your blood drawn?
Yes, they'll have it drawn by a registered nurse.
Fascinating.
Title 17 of the government code governs all tests like that. And the blood tests specifically are the most accurate. So if a person knows they have only had 1 drink or 2 drink and they're definitely not .08 or not impaired in their mind, the blood test is what they want to opt for. Even though they know they're going to be arrested, they're going to be booked, they're going to be given a court date, but the case will probably not be filed once the blood test results come in. If they're not sure and they have a question in their mind, then of course they want to take a breath test because the blood test is too accurate, and they want a little room for argument as to how accurate the breath measurement is. And it also depends on how close to the time of driving it is. If it's not within 3 hours, it can't be used.
Well, and the vehicle code specifically talks about blood alcohol levels. So the most accurate way to determine that then would be to get a sample of someone's blood and test the alcohol level.
They've changed that. Now there's 2 separate, I'm sure Ken will agree with me, there's 2 separate measurements. It's a violation of the B section of 23152 of the vehicle code to have either 0.08% by volume of alcohol in your blood, also 0.08 by volume of alcohol in your breath.
Oh, so they can test your breath as well, and it's still an infraction if the machine comes back at 0.08 or above.
Correct.
Okay. Well, let's get back to our incredible scenario here, our journey into the criminal justice system. They've taken you to the station, and you've blown into the intoxilizer, say, for example, and the results come back over the legal limit. Now what happens?
You're going to get booked. They're going to, in most cases, they will cite you out. They'll give you a date for court to return to court. They won't let you drive home, of course. They'll have somebody, allow you to call, have somebody come pick you up, and you will be given a court date. And unless you have a warrant, if you have a warrant outstanding, if it's a $200 parking ticket warrant, they're going to keep you in custody.
Well, I've heard him say on television, book 'em, Dano. What is involved in booking? Is that pictures and the whole?
That's pictures.
With the number being held in front of you and the whole thing?
That's it. You're fingerprinted, your photo's taken, you're given a booking number, and that's the booking process.
Wow. And if your blood alcohol is less than the legal limit, what's going to happen to you at that point?
A lot of it depends. Well, if it comes back less than 0.08, you will still have been booked, but depending on the level of impairment, as well as the driving, The police will later refer that to the city attorneys or the DAs, and they'll decide whether or not to file a DUI case. But you are still going to be booked.
Yeah. Oftentimes, if they do find out at the station that they do not believe there's sufficient evidence to believe you're under the influence based on all their tests and the breath machine, and they have no suspicion that there's anything else involved, such as drugs, they have to, if they release you without going to court or seeing the prosecutor, they give you a certificate, which is an official document from the police department indicating that you have not been arrested, that this is deemed officially a detention only, so you never have to mention that you've ever been arrested.
Wow. So if you've had a couple of drinks and you're absolutely sure you're below the legal limit, but you get pulled over and you can't pass a field sobriety test, they're going to take you to the station. You're going to blow into the intoxilizer or give a blood sample. What period of time is involved from when you see the red lights in the rearview mirror and when you're going to be released, if your blood alcohol is less than the legal limit, if you're not even charged?
It doesn't matter what your blood alcohol level. You're still going to be in that police station 4 to 5 hours, maybe longer. It depends. If it's a Saturday night, 2 a.m., there are numerous DUI arrests. You're going to be there for a long time.
You're not getting out till the morning.
That's quite a possibility.
Oh my goodness! And that's if you're not incarcerated.
Incarcerated?
Well, I mean, if you're not taken down and your blood alcohol level is not above, if it's below,
that's all part of the
you're
booking
still
process.
looking at a 4 to 5 or more hour scenario at the police station.
Exactly.
Remember,
wow.
David, the .08 is a scientifically established average. Depends on the human being and the human being's metabolism, the human's makeup, sex. Women get impaired at a lower amount of alcohol than men do, and some people are on the continuum are impaired at .04. And the first section, 23-152A, has to do only with impairment. Blood alcohol level is just one factor.
So if you go to the station and your blood alcohol turns out to be .04, you can still be charged as a person being impaired sufficiently so that you can't operate a motor vehicle.
If you have solid evidence, if the person's stumbling all over, can't perform one field sobriety test and slurs their words and is for all intents and purposes obviously impaired, yes.
Wow. And what about if it's not alcohol? Other substances?
Well, can those do
That's
that?
also precluded under 23-152A, which provides that it's illegal to drink and to drive under the influence of either alcohol or drugs.
Or a combination of both. And you should definitely advise your viewers, they should all be advised that the fact that you have a prescription from a doctor or a hospital is of no relevance. It is not a defense to say I have these drugs or Valium or whatever drug you have prescribed. If you're impaired from those drugs and you voluntarily and knowingly took them, it's not a defense.
Wow. So you're sleepy because you're taking a certain kind of medication. Doesn't matter if it's prescribed, as long as they can prove that you were impaired,
Right.
you may very well be charged.
That's correct.
Wow. Okay. What about hiring a private attorney? Ken has talked about this whole procedure, this nightmare, I think, if you will, if you're pulled over. At some point, it seems to me, you're going to want an attorney. And of course, Ken is the prosecutor, you're the defense attorney. So the question to you is, Jerry, is a private attorney necessary?
I think it's absolutely essential. A private attorney should be called as soon as possible because the officers write down all their notes and observations almost immediately after booking you. And they're going to have that to review no matter how long the case gets. They're not going to have to memorize it. Your client has already, even if he's innocent, he's probably had 1 or 2 drinks and he's tired and he's never been through this before. So it's very important that he be what we call debriefed or interviewed as fast as possible, hopefully the next day. Additionally, when the officer books you, if he is charging you with being .08 or above percent of alcohol in your system, then he takes away your driver's license right there and gives you a piece of paper which is good for 30 days. And
At the station they do this?
Yes, they do. And you don't leave with your driver's license. You've got a 30-day permit to drive. It's a form, and in the middle of it, in small print, most people miss it. It says if you do not call, or your attorney call DMV within 10 days, the Department of Motor Vehicle, you lose your right to a hearing, and you lose your license.
So you've had a couple drinks at a party, and you are over the legal limit. They take your license that night. You go home without your driver's license and can't drive?
Well, it's more than a couple of drinks, but you can drive for 30 days. And if you haven't requested a hearing within the first 10 days, then you will lose your license for several months after 30 days. If you do request a hearing within 10 days, then they have to stay the suspension until you have your hearing.
And if you're driving without a license, what's the...
If you're driving without a valid license at the time of a DUI, you're going to go to jail.
What about if you lose your license as a result of this and they catch you driving?
That is that's a more serious offense. That's a 14601.2. I know we don't get into numbers, but that's driving with a suspended license based upon a drunk driving charge. Basically, requires mandatory jail time as well as a $300 fine.
Wow.
Also, you'll be in violation of your probation because you'll be on probably 24 or 36 months probation for the driving under the influence, and then you're caught doing a separate crime of driving while your license is suspended for driving under the influence. So you face that new case, which Ken just said, involves a minimum amount of time in jail, and then you're also going to be violated and could spend anywhere up to 6 months in jail for violating the conditions of your probation to not drive without a valid driver's license.
And what's important to remember is that any DMV suspension is going to be consecutive to any court suspension or restriction. They go one right after each other.
So you could find it very difficult to move around town for
Yes.
quite a period of time.
Yes, you could. You can. And even if you do everything right and you're convicted and it's your first time and you enroll in the alcohol program, you still have 30 days of no driving from DMV if it involves a .08. If .08 or blood alcohol level is not involved, such as with drugs, just plain impairment, or lower than a .08, then you do not have the DMV suspension. But if you do have a .08 or above, you're going to lose 30 days of driving no matter what, even if you're Mother Teresa.
Wow.
Yeah.
Now, I know we've talked about .08 a number of times, and that's the presumed limit. Wasn't it different in the past?
Yes, it was originally, years ago, it was 1.5. It was later lowered to 0.10%. And in 1990, I believe they lowered that to 0.08%.
So the presumptive level of being intoxicated or impaired is half of what it was a number of years ago.
That was a long number of years ago. But
Wow.
it really has increased the public awareness. And I was mentioning this to Gerald earlier, the stats from 1990, according to the DMV, there were 366,000 arrests in California for DUI. And in 1999, there was 190,000, so that's almost a drop of half.
I think we've changed the limits, not because the science is any different than it was then. The reason we've changed the limits is we decided that number one, they didn't want trials where people, alcoholics, would get up and they'd put on the defense with an expert that at .13, they're fine, where the rest of us would be falling apart. They decided they've had it with that, and they're moving towards a more zero-tolerance state. And so a lot of people can be impaired at .08, and it's going to get a lot of people that are not impaired, but they say they're not concerned anymore. They want to make sure no one's over .08 because in their feelings, the average person is probably impaired.
But if we're looking at just the statistics to tell the story, the tougher standards do seem to be working. You would expect a tougher standard to yield more
cases.
More cases, and the opposite seems to be true.
I think what it is public awareness. There's
Wow.
more talk about designated drivers now,
Right.
having somebody there, to drive everybody else that's been drinking. So I think that cuts down on a number of them.
The new generation is taught this in school, where our generation was not. And I know with my kids, it was always that way. They were learning this in school, and they were learning designated drivers, and they were learning that there's zero tolerance under 21. You lose your license for .01 or above. And I think that's had an impact.
Wow.
There's SAD, there's Students Against Drunk Drivers as well as MAD. There's several programs like that.
Wow, wow. Now, Ken, what happens if you get convicted? Let's talk about just the costs.
Money costs.
What's it going to cost you if you're found guilty or you plead guilty?
If you're convicted of a DUI in California, there's a $390 mandatory fine, and on top of that, there's a 190% penalty assessment. So that's going to take you close to $1,200. In addition, there's a $100 minimum to the state restitution fee. You're going to be required to attend a 90-day alcohol program. There are costs involved with that. Those costs are sliding scale. And in addition, you're going to have attorney's fees one way or another, whether you have a public defender or a private attorney.
Wow. So we're looking at $1,500 or more just of the court system, plus 90 days in an alcohol or an AA kind of program.
Alcohol program, correct?
Plus a private attorney. Jerry, what's that entail?
Well, every case stands on its own, and no matter how much our subject is generic, you've got to understand that almost every driving under influence that comes in my office is different than the next one. So I can't tell till the initial interview, but I would say a standard driving under influence case that does not go to trial is probably going to run you legal fees somewhere in the nature of $3,000, including the DMV proceedings. I know people that charge as much as $5,000, some as low as $1,500, but $2,500 to $3,000 is pretty much standard.
So if you see the red lights in the rear view mirror, I keep going back to this, but if you see the red lights in the rear view mirror and you are impaired, you've just spent $4,000 to $5,000.
More.
Or more.
Forensic alcohol expert hired by your defense counsel is going to cost you another $450 to sometimes $1,000 to determine what your alcohol level was at the time of driving.
Even first offense, you're going to pay these fees?
Even first offense. Those are all mandatory fees, the fees I spoke of.
Wow. What about jail time, first offense? You going to jail?
In most DUIs, you are going to jail. There is one scenario where you're not going to jail. That's a first-time misdemeanor DUI with no injury. However, there are enhancements, and even in those cases, even if it's your first time and it's a misdemeanor, you're going to jail. That would include a refusal to take a chemical test, not having a valid driver's license at the time of the arrest, having a child under the age of 14 in your car, which is now another a big thing, because you will, in all likelihood, if you have a child under the age of 14 in your car, you're going to be charged with a separate count of a child endangerment. And in another enhancement, which is a 60-day mandatory jail time enhancement, is the speed exhibition or reckless driving, which means if you're going more than 30 miles an hour over the speed limit on a freeway or 20 miles an hour over the speed limit anywhere else, that enhancement applies, and that is 60 days minimum.
60 days.
In county jail.
County jail. Not a fun place to visit,
No.
from what I hear.
No.
Okay. Wow. Jerry, we've talked a little bit about DMV and the court system. Tell us a little bit about the different ways that those two, or the different ways that those interact.
They're very important because most people go to court and they say, you say, well, when is your DMV hearing? Or when they contact you for court, they've waited more than 10 days because the court date, if they're released and don't have any other warrants, is usually 30 days henceforth. So what happens is they wait and they don't call DMV within 10 days because they think everything's going to be done in court, which is what the citizen usually thinks, but that's not correct. DMV and court are two different things. They operate totally independent of each other. DMV can do one thing, the court can do another. Your license status is actually more controlled by the Department of Motor Vehicles. So if the judge just gives you a restriction, the fact that DMV gives you a suspension or holds a separate hearing, the judge's restriction does not overrule the suspension.
So someone would need representation potentially before the DMV and the courts?
Yes.
Wow. Okay. Well, to summarize up a little bit, if you get pulled over, what advice, or if someone gets pulled over, what advice do you generally give somebody?
Be cooperative. The best thing you do is be cooperative because there's even a box on the police form that says whether you're cooperative or not, and the city attorneys look for that. They look and see if you've been cooperative and what your attitude was. And also, if you feel that you're not impaired, you might want to go along with the test, take the preliminary alcohol test, and ask for a blood test, and be as cooperative and work with the officer as much as possible. It'll result in your car not being impounded but parked at the scene. If you have a good attitude, if you don't, your car is going to be impounded and cost you another hundreds of dollars to get it out. So that would be my advice, and then take a blood test.
And probably get an attorney if...
Within 24 hours of being released, obviously not in the middle of the night if you're released at 4 or 3, but the next day you should be contacting someone about an attorney.
Yeah, yeah. Where can someone find a good attorney? Any thoughts on that?
Well, if you know a family member or a friend that's been arrested for DUI, or they're familiar with a lawyer, maybe through the friend or family.
Probably the best way, referral, or one of the best ways?
Yes, personal referral.
Yeah. Other ways, Jerry?
Well, there's other ways that I wouldn't condone. One of them is called jail mail. And that's where lawyers pay a vast sum of money to have everybody who's booked sent mail to their residential address, telling them to hire me and giving brochures and all kinds of lead-ons.
Right.
And the problem with that is there are some obviously qualified lawyers in there, but you don't know who they are or which ones they are. There's no screening whatsoever. I would suggest that people contact a friend, a family lawyer that doesn't practice criminal law that they know may have an excellent referral to a criminal defense associate, or the lawyer referral service. And there's one for the San Fernando Valley Bar Association. And
what's the advantage of going to the referral service?
The reason is this. Every lawyer to qualify to be on a panel, for instance, in this case it would be the criminal law panel, would be screened under state bar provisions to be qualified to represent people in criminal matters and in driving under influence matters, and they'd also be required to carry malpractice. So you're much better off going through a qualified service like the lawyer referral service of the Bar Association than you would be taking someone you don't know.
So the next best thing to personal referral, you would think?
Yes.
Okay. Okay. What about this?
Is your audience primarily in the San Fernando Valley?
Exactly.
Well, the San Fernando Valley Bar Association is the largest bar association in the area, and specifically in the San Fernando Valley, and they have a phone number of 818-227-0490, and you can call, and I believe for a nominal sum of $35, you get a half-hour free consultation with a lawyer, and that should be your first move if you have no other resources.
Good first step. Good first step. Well, that's all the time that we have. I want to thank both of you for coming in and certainly enlightening me as to how bad it can get so quickly if you get pulled over, even if you are not over the legal limit. I'm shocked. You may not get home till the next morning if you're pulled over and your blood alcohol is less than the legal limit. Very interesting. Very, very interesting. That's all the time we have then. I want to thank our guests, Jerry Fogelman and Ken Sue. Thank you for taking the time this afternoon to come down and see us. This is David Hagen. Till next time.
This has been Legal Forum, brought to you by the Lawyer Referral and Information Service of the San Fernando Valley Bar Association. The Lawyer Referral and Information Service and the San Fernando Valley Bar Association have been serving the San Fernando Valley and adjacent communities for over 75 years. For further information, you may contact the San Fernando Valley Bar Association.